Final case set for argument this morning is the Homless Charity et al. Versus City of Akron. It's case number 29334. Both parties are present, so each of you will have 15 minutes to present your arguments to the court. The appellant may reserve up to 5 minutes for rebuttal. While we do have the clock on the TV screen there, if you let me know how much time you're going to reserve, I'll try to also interrupt you if we get close and let you know how much time is left. The court has read the briefs in this matter. We are prepared to proceed if you are.
Thank you. May it please the court, I'm Diana Simpson on behalf of the appellants, the Homless Charity, Sage Lewis LLC, and Sage Lewis. I'd like to reserve 5 minutes for rebuttal.
Thank you.
The lower court should be reversed for 2 reasons. First, it is appropriate to send a notice of appeal to the Akron Law Director, who represents the city and its agencies at all times. Second, when a clerk's error is the reason a notice of appeal is not timely filed, the U.S. Supreme Court has said that due process requires an opportunity to correct the error. I'll start with the Law Director and then move to due process. The Law Director is an appropriate person to receive the notice of appeal. No law or ordinance specifies whom to serve, and the letter that the City Council sent Sage didn't specify either. All the law says is that the notice of appeal must be filed with the agency. The City Council is not a natural person, so we must send it to somebody. And the person who makes the most sense to receive a notice of appeal is the Law Director.
I'm wondering why wouldn't be the most appropriate person would be the clerk of council.
Your Honor, the Administrative Appeal Statute, RC 2505.04, does not specify whom to send it to. All that matters is that the agency receives it. And because the Law Director represents the agency in all circumstances, the Law Director, when she receives it, it is the same thing as the agency receiving the notice of appeal.
Although the statute could say the agency or its legal representative.
Yes, Your
But
Honor.
it says the agency.
Yes, Your Honor. But City Charter Section 62 specifically states that the Director of Law is the legal advisor of and attorney and counsel for the city and for all officers and departments thereof in matters relating to their official duties. And it is long the case that to serve a party's attorney is the same thing as serving that party. And so to say that the notice of appeal must go only to the clerk of city council is to add an extra requirement to the administrative appeal statute. But Welsh says that you can't do that because the purpose of a notice of appeal is notice. And under Welsh, the only question is whether the agency has received notice. And when a law director receives the notice of appeal, it's the same thing as the agency receiving it because the law director is the agency's representative. And practically speaking, the only thing that city council staff would do with a notice of appeal is to give it to the law director anyway. Here, the Akron Law Director is the lawyer for the City Council at all times, whether they're acting in their adjudicative or legislative capacity. So serving her is the same thing as serving the agency. Ultimately, if the Law Director had received the notice of appeal, filing would have been complete and the court would have had jurisdiction. But the clerk's error prevented that from happening. Let me turn now to due process. Courts do not lose jurisdiction due to an error committed by the clerk. Upon accepting the precipice directing service to the law director, the clerk undertook the duty to serve the notice of appeal and the obligation to properly execute that duty. The clerk's duties are set out by statute, and the clerk has the statutory duty to issue process once a precipice has been filed. That's from RC 2303.11. In performing official duties, the clerk operates as part of the judicial branch. That's from RC 2303.26. So we know that the clerk error is imputed to the judicial branch as though the court itself had committed the error. And it is this statutory duty that distinguishes the clerk from a private actor like FedEx. FedEx is not a judicial entity and it has no statutory duty to act. And so though litigants bear the risk of a FedEx error, they do not bear the risk of a clerk of court's error. Here, the clerk did not properly execute the duty and failed to timely deliver the notice of appeal to the Akron Law Director. The court below held that this deprived it of jurisdiction over the case, but that can't be, because due process prevents judicial errors from terminating jurisdiction due to a clerical error. The right to appeal is a property interest protected by due process. That's from Atkinson at 84. When a judicial error terminates a litigant's right to appeal, that is a due process violation. That is what the U.S. Supreme Court said in Logan, what the Ohio Supreme Court has said in Atkinson and Sauter v. Gray, and what the Texas Supreme Court said just a few months ago in Mosley.
Let me back up, please. You said it's a statutory, these clerk of courts has statutory duties and this is serves statutory functions. And that's what the difference is here between the cases that talk about FedEx or USPS or whoever. I guess my query is, isn't this different though in the respect that you didn't have to go through the clerk of courts? You know, in those cases that you're citing, the only avenue of delivery was through the clerk of courts by our law.
That is correct, Your Honor, and perhaps if we had things to do differently, we would do them a little bit differently this time around. But the ultimate lesson of the statutory duty is that once the clerk accepts that precedent directing her to serve a notice of appeal, she has the requirement that she do that correctly, and her failure to do that correctly creates a due process violation when it prevents someone from being able to litigate on appeal their case, which is exactly what's happened here. And so it doesn't matter whether the error relates to when a judgment is entered and the clock starts ticking for an appeal, or whether it's about reopening an appeal window that has already closed. The only important question is whether a clerical error deprives the litigant of his right to appeal. It's precisely what happened here. The Court of Common Pleas failed to recognize that terminating an appeal due to a clerk's error created a due process violation, and that is a reversible error of law. If Your Honor doesn't have any questions, then I will address this on rebuttal.
Okay, you'll have a full 5 minutes for rebuttal. Counsel, you'll have 15 minutes.
Good morning, Your Honors. Brian Bremer on behalf of the City of Akron. The issue before you today is a straightforward one. Did the Common Pleas Court correctly dismiss appellant's attempted appeal? The answer is yes, because the appellants failed to perfect their appeal as provided for under chapters 2505 and 2506 of the Ohio Revised Code. Appellants attempt to navigate around the existing case law and the actual common sense result that the case law dictates by suggesting that someone else made an error in this case. The only individuals that had the duty to actually file the notice of appeal were the appellants. The appellants had the duty to file it with the agency. They failed to do that. The clerk of courts, there's no evidence in this record that the clerk of courts made an error. And even if the clerk of courts did make an error, that error did not deprive them of the right to appeal. Their failure to file themselves deprived them of the right.
Well, you know, just like I just asked opposing counsel, you know, the cases that really both sides are citing are a little bit different, you know, obviously. But in this situation, they have the right to use the clerk of courts to effectuate the service.
Right, and in Walsh, the Supreme Court said you have the right to use whatever conduit you choose, be it the clerk of courts, FedEx, the Postal Service, but you bear the risks that if that fails, you fail to file your appeal. It's still your failure, and in this case, it's their failure, not the clerk's, to the extent that any error occurred. And again, the record in this case indicates that the error, if it was made by the post office, and it's pure
Well, I
speculation.
think that's kind of in dispute, isn't it, though? It's not really clear one way or the other.
There is no evidence that the clerk made the error. Every single
Well,
thing
they
is.
signed for it, right?
They signed for it when it got delivered to them.
That's not an error?
No, I mean, it was handed to them by the Postal Service and they accepted delivery of it, but that's not error in how they addressed it or anything else like that, which is what their accusation is.
So your argument is the post office got a perfectly addressed envelope to 161 and delivered it just right back to the people that gave it to them?
I would say that in my experience, the Post Office does not put that beyond probability. The Postal Service does make errors, especially when there's big groups of mailings going out, like such as this. The clerk of courts would receive and send out immense amounts of mail. And the evidence in this case was they requested to be sent to the law department at the city of Akron. The clerk reports then, in the certified mail, evidence we got from the postal service, was sent to the law department at the city of Akron, and then it got delivered to the clerk of courts. And in any case, it's undisputed that it didn't actually get to where it was going. And even if it had, serving the law director is not service of the agency. It's not filing with the agency. And that's well established from decades of case law in the state of Ohio. And this specific fact pattern has been addressed by this court 2 different times, in Lorenzo Properties and in Highland Square. In both cases, those involve the appeal of a city council decision from the Akron City Council, and the plaintiffs failed to file it with the city council, and instead attempted to file the notice of appeal with the city of Akron law director. And again, in both cases, this court has come to the conclusion that the appeal was not perfected properly. And in those cases are binding, and this goes also to why the suggestion that the statute is ambiguous is a little disingenuous from appellants in this case, because the statute says you have to file it with the agency. It's pretty clear that it has to be with the agency. And to the extent that they are saying they don't know who to file with, the result of that would be maybe to go read case law and see what the courts have held about where to file it. And in this case, the courts are.
So I'm sorry for interrupting, but you know we have limited time, so we
Yeah.
gotta get some things in. So you're saying there's no way that the city of Akron, through the law director, could accept service and waive it on behalf of the city council?
Correct. The city of Akron director of law does not keep the records for city council. The city of Akron director of law did not send out the notice of the written decision of the city council. That was all done by the clerk of council, who by charter is the keeper of the records for city council. And also, when you review the record that was filed in this case, you'll see that that was actually also known by appellants. Ms. Simpson actually filed documents with the clerk of council in this case. She did that. She knew where to file it. She just chose not to do it here. And that is, the idea that they didn't know where to file with the clerk is just,
Well,
that's
that's
important.
a little different, isn't it? That's like you're in trial, okay, and you might send a, copy to the attorney, but you have to file stuff with the court. So at council, that was like the trial court level. So they had to file stuff with the council at that time.
and just like when you file a notice of appeal, you have to file with the trial court. You don't file, you have to file it up here eventually, but what matters is filing with the trial court. And that's jurisdictional, just like filing with the clerk of council would be jurisdictional.
Well, they don't have to file with the clerk of council. Do they only have to serve the clerk of council? Is that what the statute says?
They have to
It doesn't say
file
it has
with
to
the
be filed with the agency.
It says they have to file with the agency. Filing with the court does not, for the common police court does not perfect the appeal. It has to be filed with the agency. And that can be done through service, like that could be done by certified mail, by post being sent there, or it could be done by walking over and hand delivering it, which is the way typically it's done.
If they had served each individual city council member in their capacity as a council member, would that have counted?
No, I would say no. The keeper of the records is still the clerk of council. And then again, the clerk of council was the individual who sent the letter, and the letter did have the address of the clerk of council at the bottom. And again, the clerk of council was who they filed everything with during the proceedings before the council. Except for the proceedings, there were some filings that were done before that because there's a hearing for planning commission and the actual planning department leading up to the council getting it. But then after the council received the conditional use petition and came before it, then they started filing with the clerk of council itself. And again, that's in the record that they knew to do that. And again, they make a suggestion in their briefing that if they were to communicate with the clerk of council, this would have been an ethical violation. Well, Ms. Simpson did that in the proceedings leading up to the petition being heard. So if that is a violation, ethically, everyone at that table should be reporting Ms. Simpson to the Ohio Professional Ethics Review Board, because she violated the professional rules of conduct. But that's not our position, because our position would be that filing with the clerk of council is not an ethical violation, because it's required by law. It's required by this court's jurisprudence, it's required by case law across the state, and if there was a problem with it, it would have come up at some point in the last 30 years or so. But as far as I'm aware, and they've never cited anything to the contrary, no one has been found to be in breach of the rules of professional conduct by filing a notice of appeal with the administrative body that made the decision. So,
Well, and I'm gonna go back to the waiver issue. So your thing is just a straight statutory construction argument. They just didn't follow the statute.
correct.
But you're not disputing that the city law department or the city council knew about it because of sending the record over 800 pages of transcript that was, provided and so forth, and I guess some comments in the newspaper as well. So it's not like anybody didn't know what was going on.
This court has held previously that knowledge of the lawsuit is not sufficient to create jurisdiction for the courts. And in this case, knowledge of the lawsuit is not, that same fact would apply here, except it's even more specific about when you don't follow the statute to the letter, you don't have jurisdiction in the trial court, in the common pleas court of an appeal like this. And it's also worth noting that, again, the Department of Law never received this notice of appeal within the time period that it was served. And that's not in that, and I will acknowledge it's also not in the record, that's just, they keep raising this issue that the law department was very specific about how they phrased the motion to dismiss, only referring to the clerk of council staff. Well, we did that because the clerk of council staff's the people who needed to actually receive this notice of appeal, and we didn't feel the need to actually justify not receiving it in the Department of Law because this court has held repeatedly, serving the City of Akron Director of Law is not the same as filing an appeal with the City Council. But the City of Akron did not receive this notice of appeal before within the 30 days after the City Council made its decision.
How soon did the city file a motion to dismiss the appeal?
The city filed a motion to dismiss in December, I believe it was on December 5th. So it was a little under 3 months after the City Council made its decision, and a little under 2 months after the notice of appeal needed to be filed.
I was just wondering about that because it seemed like there was a little bit of lag time in regard to filing a motion to dismiss when it hasn't been filed with or hasn't been served on you.
Well, if we haven't been served with it, that would of course be a reason not to file a motion to dismiss, but we filed the record, I understand. And
that's what I mean, because that's a lot of documents.
Yes, we wanted to, we knew that this was a very high profile issue, and we knew that it was likely to be very litigious, and so we wanted to make sure that we complied with the deadline as if they had properly served it, so that we didn't have any fights about whether we comply with the statute or anything like that. And then we were preparing the motion to dismiss, and again, we were taking our time, being cautious, so that we weren't taking a position that was inappropriate. And that's why the filing occurred when it did.
Now, I don't recall exactly what the entry says, but did the lower court address the charity's constitutional arguments in its rulings for summary judgment? And if not, is that an issue?
Well, again, it wasn't summary judgment, Your Honor, it was the motion to dismiss.
The motion to
Yes,
dismiss,
but
I misspoke, sorry.
no, and it was not, the court did not address the constitutional arguments, but it was also appropriate for the court to decline to do so because the court did not have jurisdiction over the appeal. If this is a matter, because it was an administrative appeal, the way to properly, they need to actually file with the clerk of council before the court can take control of the case. And then what they filed with the court of common pleas itself wasn't actually like a complaint that would have initiated a lawsuit. So it's a little bit, that's part of the situation here, is that the court just did not have jurisdiction over this case.
Thank you.
But in order to determine if it had jurisdiction, wasn't it mandated to look at the constitutional issues? I understand what you're saying. Obviously, if you don't have jurisdiction, you can't start just deciding everything.
Oh, I'm sorry. I thought Judge Udosi was referring to the constitutional arguments about the right to use the property. I didn't realize it was the due
I
process.
misunderstood him.
No, I'm talking about the clerk, the due process arguments raised by the chair.
I do not recall whether the court directly addressed that issue. However, due process, I will say that they cite to a Supreme Court case talking about due process and how courts can't defer their own jurisdiction. But in that case, there's a footnote that specifically talks about this exact scenario where it's the appellants that fail to invoke the jurisdiction, not the courts. In that Logan case, the tribunal had jurisdiction because they timely filed their petition with the court, and then they didn't rule within time, and the Supreme Court said, no, you can't fail to rule and then lose jurisdiction. But they say in a footnote specifically, that is not true of a case where the appellants or the petitioner fails to actually comply with the statutory timelines, which again is what happened here because they failed to actually file their notice of appeal with the City of Akron Clerk Council. It is not, and again, I think it's worth noting that they knew to file with Clerk Council because they filed there previously. The Clerk Council sent out the notice to them of it was the written decision saying City Council denied your petition, which they were aware of because they were at the meeting. I believe they were at the meeting on Monday before. But then they sent the notice, and then if they had any doubt about where to file it, this case law of this court clarifies that issue, and the case law across the state clarifies this issue. And Welsh did not change that case law. Welsh specifically says that you still you can use whatever conduit to perfect service that you want, but you bear the risks associated with that conduit. The only people that had a duty to perfect the appeal were the appellants. The appellants failed to do so, and the trial court lacked jurisdiction in this case. So the trial court correctly dismissed the attempted appeal. And again, I want to reiterate that the evidence in this record is pure speculation that the Clerk Council made a mistake. It's also speculative that even if there was a mistake, whether the City of Akron would have been served the same day within the time period that it needed to be, even if the law director could have received service. Which I understand the clerk of course is next door to the city, the building they were trying to send it to. But at the same time, it's not entirely clear that would have made it to the City of Akron Department of Law that same day. And it was served, sorry, I'm over my time.
I was just going to say, Council, you're over time, but thank you for your argument today. We have 5 minutes for rebuttal.
Thank you, Your Honors. I'd like to address 3 points on rebuttal. As an initial matter, courts always have jurisdiction to determine their own jurisdiction and to address any constitutional problems that arise as a result of the elimination of jurisdiction. The court below did not substantively address any of our due process arguments about the clerk of court's error, but summarily disposed of the issue in one sentence. Second, there is evidence of clerk error, and the record clearly states that. There is no dispute that the letter was delivered to the clerk's office and signed for by the clerk's office. The most reasonable interpretation of these events is that it was addressed to the clerk's office. It doesn't make any sense that they would sign for mail that is addressed to somebody else. Importantly, the clerk then updated the service tab to reflect that Importantly, the clerk then updated the docket to say that service had been successfully accomplished on the law director. And neither of these errors can be imputed to either Sage or to the post office, and both terminated Sage's right to appeal in violation of due process. To the extent that the city relies on that post office document that they submitted as an attachment to their reply to the motion to dismiss below, this court should not consider that document because it was never actually submitted into evidence or subjected to a fact hearing. We don't know how it was generated or where the information in it came from, and appellate courts just don't consider documents like that, as this court said in Cardone v. Cardone at *1. Third, the case law that the city cites for the suggestion that the law director is inappropriate doesn't apply here. So most of the case law from this court that states that predates Welsh, and Welsh really changed the analysis of this issue. Lorenzo is distinguishable on both the law and the facts. On the facts, there was no court error in that case, and the notice of appeal was late. Here, but for the court error, the notice of appeal would have been timely. And as for the law, To the extent that Lorenzo talked about service on the law director, it never considered the arguments we raised here. And as for Highland Square Management, that case is this court's most recent discussion of the issue, and it expressly left open the possibility that service on the law director could be sufficient if an appellant made such a showing, which is what we've done here. The most important case for this court to look to is Welsh, which made clear that the purpose of a notice of appeal is notice, and that the law director represents the city agencies in every moment. The law director is the alter ego of the agency, and if the law director has notice, the agency has notice. Any suggestion that the city is making that the clerk of city council is the only entity to serve adds a requirement to RC 2505.04, which Welsh expressly said courts could not do. All
Depends
that
on
matters.
if the statute requires it to be filed though with the agency.
Yes, Your Honor.
That's the only entity that can file as a clerk of council. Clerk of council.
Yes, Your Honor, but the director is the alter ego of the agency, and so providing her with the notice of appeal is providing the agency with the notice of appeal. Ultimately, right, I suppose, in conclusion, appellants respectfully request that this court reverse the court below and remand with instructions to allow us to refile the notice of appeal and allow the case to proceed on the merits.
Thank you both for being present this morning and providing the court with arguments. The court will take this matter under advisement as well as issue a decision in due course. Each of you will receive a copy of the court's decision on the day it's released from the clerk of courts, hopefully. And you can also check the Supreme Court of Ohio's website where the opinions are posted. The court will next be in